All set. Court does call the case of the people versus Salvador Dorentes.
Ready, Your Honor. Joe Simon on behalf of Mr. Mariante. Please wait at the podium.
Your name, sir?
Salvador Docket, Jr. Your Honor.
All right. Go ahead.
And Your Honor, we're here for arraignment.
No, I'll wait for you to get off your phone.
Oh, Your Honor.
No, I got time.
We're here for arraignment and pre-trial. For the arraignment, we wait for reading.
Defendant Avery Wade, former reading, standing mute. Court will enter a not guilty plea.
Your Honor, the people and I have been going back and forth on media that we requested, specifically the videos. Ms. Lonnie is a little stymied as to why they haven't yet been released to her. She's following up on their according to the requesting during the pre-trial. We also have a trial.
Will April 2nd work?
Your Honor, that is a pretty difficult day. What is the very next available? Otherwise, I'll
Simon.
Or 23.
Oh, I don't think you don't. We'd rather check that. Yeah, and I'll if I can come a little later than Your Honor, I'll make that.
We will wait with bells on. April 2nd, 2025, 9 a.m. or as your invite indicates, or whenever you decide to show up. All right. And as to bond, alleged BAC in the matter.
0.128, Your Honor. For the crash into a parked vehicle.
So there's an, okay. Thanks.
No history that I'm aware of.
Mr. Simon.
Your Honor, my client is 47 years of age, no prior convictions whatsoever. He's already been screened and assessed by bonds and works. He's already completed the aftercare that was recommended. I don't dispute there was an accident, Your Honor. There was a striking of mirrors, side mirrors on the vehicles. And clearly that would qualify as an accident, but crashes perfect connotation, I think. Nevertheless, and then so we do request a personal guidance, but he has a travel coming up this weekend that we're going to be requesting.
Very lawyerly argument.
Very much.
Lawyerly argument on the definition of crashed. No, I'm pondering it. Okay. Done now. I'll set the defendant's bond at $10,000 personal recognizance bond, standard conditions, including no assault to behavior, possession of any weapons or ammunition. There's to be no use of any alcohol, recreational marijuana, or any illegal drug. I will order the defendant is to report over to community corrections for placement on the sober link. Travel.
Your Honor, my client and his wife prearranged travel March 22nd, this upcoming weekend to March 25th. They want to go to Nashville, a very short spring break.
To Tennessee? Okay. Said 22nd through the 25th.
Yes, sir.
I'll indicate defendant may travel to Tennessee on those dates inclusive. You're leaving on the 22nd. You'll be back you're traveling on the 25th.
Yes, sir.
Okay. So those dates inclusive.
Thank you.
All right. Thank you.
Your Honor, I know this is the risk of my own peril. Ms. Lonnie and I approached her briefly on a different matter.
Is there anything about basketball? Because if it is, I'm coming off the bench.
And no, you're
Okay, come on.
You'll notice I've not mentioned.
I know you are being very, very good, but I know what's going on in that head. And it's bothering me. All right. Yes, you may.
Thank you.
All right. To get somebody else. Yeah. Court does call the case of the people versus Shane Young.
Good morning, Assistant Public Defender, Lauren Attorney on behalf of Mr. Young, so I'll state your name for the record. Your Honor, excuse me, we are asking for another adjournment of this case. Mr. Young was scheduled to have an exam yesterday and a felony file that has been adjourned out until April
8th.
14th. So
Who's that before?
I just thought it was in front of you, but I went in front of ours.
and then Mr. Burgess was in trial.
Okay, so he's right. I was in the building when that was going on, but I don't. It can't be the 14th.
Yeah, that's a Monday. So you're usually on Tuesday.
I'm gonna suspect. I think Judge Barr is back on the 8th.
That's correct, Your Honor.
I think it's the
I
8th.
know.
Huh? Yeah.
Well, that's better.
No, it's okay. I realized I wasn't aware that it was his case, but there was some talk of an adjournment, probably too much talk. But anyway, so he needs a date after that date. Is that the deal? Or
I think we could get this done by the second. I think Mr. Stiller and I spoke this morning. I think we have a resolution. We just want to tie up some loose ends. That's why we're requesting adjournment. I think the second should be okay. That'll give me time to do it.
all right. April 2nd, 2025, 9 a.m.
Thank you.
You're welcome. Bond continue. Court calls the case People versus Stephanie Hirsch.
That's a lot of people.
Thank you.
Yeah, we are to submit our quick trial. The defendant has satisfied all the requirements of an agreement that we made. Case will be dismissed.
No objection, of course.
Case is dismissed. Thank you.
Thank you, Judge.
Court calls case People versus Walter Ruff.
That's a lot of people. So Your Honor, Mr. Ruff was transferred from Washtenaw County Jail to Livingston on the 13th. He called our office as well as my understanding the clerk's office. He was released from Livingston County Jail just this morning and is on his way here. As of 10:49, he said he was about an hour away, but isn't coming here in person. I'm asking if the court consider passing the matter to your eyes.
I'll pass it.
Thank you.
He doesn't show. Court calls the case People versus Logan Cyrus.
Good morning, this is Public Defender Lauren Perry on behalf of Mr. Cyrus. Mr. Cyrus, please state your name for the record.
Thank you.
Here we have come to resolution. Mr. Cyrus is going to plead to an added count of retail fraud third. James Burgess has low count one. Rachel Brown, the third degree is 93-day misdemeanor, $500 fine or trouble amount, contrary 750-3564. That is an accurate resolution of the agreement.
May I have him sworn?
First project. You solemnly swear to affirm the testimony about the Yes. Sir.
Sir, it is the court's understanding you're going to plead guilty to the charge of retail fraud in the third degree. That is a misdemeanor punishable by up to 93 days in jail, $500 fine plus court costs. Fine could be increased to 3 times the value of the property taken. If that's greater than $500, that would become the maximum fine. You understand that?
Yeah.
And still wish to plead guilty?
Yeah.
And to that charge, how do you plead? Now, you understand that by pleading guilty, you will not have a trial of any kind. All right, you signed an advice of rights form, is that correct?
Yes.
Any question regarding any of those rights? Please look at paragraph 5 on that form. Those are your rights, which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes.
You understand you're giving up your right to appeal of right. Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today to get you to plead?
No.
No? Okay. Nobody's promised you anything else, correct? Anybody threaten you or coerce you in any way to get you to plead? Okay.
Yeah, I'm on probation.
You are on probation. Oh, okay. And were you on probation as of the date of September 2023?
Yeah, I believe so.
All right. So the court does have to advise you that your entry of a plea in this case could be a violation of that probation. If it is considered a violation of that probation, that court could sentence you to the maximum allowable under that other charge. You understand that? And you still wish to plead guilty to this charge? All right. Has anybody threatened you or coerced you in any way to get you to plead? You're doing this voluntarily?
Yes.
Of your own free will? And because you believe that you're guilty of this offense?
Yes.
September 20th, 2023, at the location at 3825 Carpenter Road, that being the Meyer. What did you do on that date that makes you think that you're guilty? Some what?
Food.
Some food?
Yeah.
Okay, so you went into the store and tried to walk out with food without paying for it? All right, store was open to the public at the time?
Yes.
You didn't have anybody's permission to take that property, did you?
No.
And this food or other items that you took, this was property that was offered for sale by Meyer? Counsel, have I complied with the court rule?
Yes, sir. That's fine.
I knew it. What was the holdup? All right. Court will accept the defendant's plea to count 2. Count 1 is dismissed.
Your Honor, I would ask for immediate sentencing. He has 98 days credit.
Has he, is there any restitution?
There probably is, Your Honor.
Okay.
I'm not, I double check. Sorry, I was thinking about a different case. Okay, there's about $540.
Yeah, okay. So we need a determination of restitution. So I'm going to refer the defendant to probation for a pre-sentence investigation and report. Sentencing will be
April 9th at 9 a.m.
April 9th, 2025, 9 a.m. or as his invite indicates. I'll set his bond at a personal recognizance since it's not, he's not going to need it. April 9th.
Okay.
All right. Thank you.
Thank you.
Court calls the case of the People versus Chiffon Hayes.
Question line for people. Good morning, Assistant Public Defender Lauren Kearney on behalf of Ms. Hayes. Ms. Hayes, please state your name for the record.
Chiffon Hayes.
Thank you.
Your Honor, I'm asking for a brief adjournment. Ms. Hayes and I weren't able to touch base prior to today.
April 2nd, 2025, 9 a.m. For bond will continue.
I'll be in touch with Ms. Hayes, okay?
Did you hear that, Ms. Hayes?
Yes, yes, sir.
All right, she'll be in touch with you. All right, thank you.
Thank you.
Court does call the case of the people versus Jacob Dorstein.
Conrad Silver on behalf of Pittsfield Township.
Good morning, Assistant Public Defender Lauren Kearney. I'm Mr. Dorsey. Who is approaching your
I
honor.
know, I don't think, he's not in custody. This is a different,
Oh. Well, he was yesterday at like 11 a.m.
Mr. Dorstein?
Yeah.
All right, I'll pass that one. Let's bring him out. Court does call the case of the people versus John Fulton. That's who it is.
Conrad Silver on behalf of Pittsfield Township.
Assistant Public Defender Natalie Haywood, on behalf of Mr. Cole, who is approaching the podium. Please state your name for the record, sir.
John.
Thank you.
Thank you, Your Honor. I have discussed this matter with my client. She would like to accept the offer extended to resolve all of these matters by Mr. Siller, which my client would be entering a plea in the case ending in 0079 to add in count 2 of allowing an ineligible person to drive. In the case ending 0240 it would be dismissed.
That is correct, Your Honor.
May I have him sworn?
Right. You solemnly swear to affirm the testimony you about to give me the truth.
John.
All right, sir, it is this court's understanding that you're going to plead guilty to the charge of allowing an ineligible driver to operate a motor vehicle. Is that correct? Okay, that is a misdemeanor punishable by up to 90 days in jail, $100 fine plus court costs. Do you understand that?
Yes.
Still wish to plead guilty to that charge? How do you plead?
Yes. I'm guilty.
Now, you understand that by pleading guilty, you will not have a trial of any kind. All right, you signed an advice of rights form today, is that correct? You signed an advice of rights form today, is that correct? Any question regarding any of these rights? Look at paragraph 5, you'll see a copy on the podium. Those are your rights which are part of a trial. You understand that by pleading guilty, you're giving up those rights as well as all the rights on that form.
Yes.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today to get you to plead? Anybody threaten you or coerce you? You're doing this voluntarily of your own free will and because you believe that you're indeed guilty. On the date of January 10th, 2025, at the location of Ellsworth Road in Pittsfield Township, Washtenaw County, State of Michigan, did you have custody or control of a motor vehicle?
Yes.
All right. Did you allow someone who was otherwise ineligible, maybe yourself, to operate that motor vehicle? Yes. Counsel, have I complied with the court rule? Would it be proper to accept this defendant's plea?
Yes, Your Honor.
Yes, Your Honor.
Court will accept the defendant's plea to count 2. Count 1 is dismissed, as well as the case ending in 0240 is also dismissed. Anything you want to say before I impose that? How long has he been in?
Your Honor, he's been in custody since February 24th. He's not expected to be released in the very near future. He's being held on an armed robbery case that's still in the PCC stage. I would ask the court to consider sentencing to a state minimums as well as time served. Perfect suspended sentence.
So he's been in since when?
February 24th.
Fines and costs of $125, 23 days, jail credit, 23, sir. Thank you.
Thank you, Your Honor.
Court calls the case. People, did we find Dorsey?
So he is in
jail, but they have him listed as 1482 for a different matter, so he is not here. He's transported to 2.
Okay.
So I guess just let me know what we're gonna be for him.
Well, are they gonna bring, he's over at 2.
Correct.
On the Dorston matter, I'll adjourn that out to April 2nd, 2025, 9 a.m. Court calls case People versus Matthew Gibbons.
Senator, this is on behalf of DC Township.
This is a quote under Natalie Kate on behalf of Mr. Gibbons, who is approaching. Please state your name for the record, sir. Your Honor, my client would like to ask for a 2-week adjournment of this matter. He is being held on other matters. Circuit court was next for the 25th this month. So I would ask for this to be set on your next pretrial docket. Your Honor.
Your name?
Matthew Gibbons.
Turn this matter out April 2nd, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
Court does call the case People versus Ashton Ebler.
Assistant Public Defender Natalie Tate with on behalf of Mr. Ebler, who is present via Zoom. Sir, can you please unmute and state your name for the board?
Ashton Ebler.
Okay.
Thank you, Your Honor. I'm requesting a very brief adjournment. I just got access to the discovery yesterday and was able to review it, but I still need to just have a discussion very briefly with Mr. Ebler about something.
April 2nd, 2025, 9 a.m.
Thank you.
All right. Thank you, sir.
All right, thank you.
Court calls case People versus Joseph Pinkston.
Public Defender Natalie Tate with on behalf of Mr. Nixon, who's approaching. Please state your name for the record, sir. So, Your Honor, there was an offer extended in this matter to which I have discussed with my client. To be candid, I was going to be requesting another adjournment to have another discussion with them about it. I'm still.
April 2nd, 2025, 9 a.m. Thank you. Court calls case People versus Trayvon G. Arraignment. G, no response. I'll issue an order to show cause for the defendant's failure. Raj Scott, I think.
Senator, still on behalf of DC Township.
Oh. You're right, Raj.
Yeah.
Okay.
Assistant Public Defender Natalie Tate with on behalf of Mr. Scott. Mr. Scott, please state your name for the court. Thank you, Your Honor. As Your Honor is aware, Mr. Scott is set for a competency hearing on one of his other cases in front of Your Honor on May 15th. I'm respectfully requesting an adjournment of this case to sometime after that date, so that nothing happens in this case until that order of competency either way is found.
Oh, okay. What date will we have after May 15th?
May 21st.
21st. Okay, I'll adjourn this hearing till May 21st, 2025, 9 a.m. That was his grandmother. Okay. At 9 a.m. So I'll adjourn this out. Bond will continue. Mr. Scott's grandmother was here, and she was here, Raj. Yeah, no, she walked out and then we called your case. So I had sent Mr. Allen out to find her, but she was outside. She went outside, but when she comes back in, we'll let her know. Okay, thank you. Wow. I mean, bless you. Courthouse case, people versus Kenneth Tennille.
Good morning. This is Officer Lauren bringing on behalf of Mr. Camille.
Good morning. What's your name? Thank you. All right.
The offer on this case is that Mr. Camille needs treatment. The cases will be dismissed. We are hoping to get Mr. Camille treatment. I believe he has a low cash bond in this case.
Yeah.
Maybe $2,000, 10%. I'd ask for a provision to be added that he may be released to treatment. He does have some pending cases in other courts, so there are a couple moving pieces that need to be completed before he's released, but I'm in communication with.
I will sign that. You need to prepare an order for both of these cases. I'll sign off.
Okay.
I don't have a problem with that.
And then we just asked for an adjournment out to allow that to take place if I know that.
I have the 2nd or the 23rd.
I think maybe the 23rd. Just
Okay, got it. April 23rd, 2025, 9 a.m.
Thank you.
All right. His bond will continue, but will be changed to incorporate that provision.
Thank you.
Thank you. That's it for that block. And are we ready on anything? Oh, yeah, okay. Court does call the case, People versus Christopher Holt.
Good morning. Lauren bringing on behalf of Mr. Holt, who's on Zoom.
State your name, sir.
Christopher Holt.
Thank you.
Welcome.
We are still working on recovery issues. I did speak to Ms. Lonnie in her office and working on getting us over that discovery. We don't have it yet, so I'm asking for an adjournment.
April 23rd, 2025, 9 a.m.
Thank you.
Bond continued.
Thank you, Your Honor.
Court call. Thank you, sir. Court calls the case, People versus Destin Hopkins.
Echelon of the people.
Hi, how you doing, Your Honor?
Good.
Assistant Public Defender Natalie Gibbons on behalf of Mr. Hopkins, who's present via Zoom. Sir, can you please state your name for the court?
Destin Hopkins.
Thank you. All right, what are we doing?
Thank you, Your Honor. I'm ultimately asking for an adjournment. I did discuss this matter briefly with Ms. Lonnie, and I did discuss with my client. So he currently has a case pending out of Monroe County, a newer case that's in early stages. That is the basis for a potential violation of probation he's on. That has not been yet resolved. That being said, he is asking for an adjournment of this case, so his potential probation violation.
In Monroe.
The new case is in Monroe. He's on probation under Hyde and Judge County.
Got it.
So
You want the 2nd or 23rd?
I would ask for the 23rd, Your Honor.
Adjourn this matter, April 23rd, 2025, 9 a.m.
Thank you, Your Honor.
All right, thank you. Thank you, sir.
Thank you, Your
Mr.
Honor.
Proctor.
Thank you. Have a good one.
You too. Court calls the case, People versus Monisha James.
People. Morning, this is the Public Defender on behalf of Mr. James.
She says, hopefully.
Hopefully.
Not here.
No, okay. Your Honor, I have no explanation for Ms. James's failure to prepare did provide her with these anyway. I would ask for an adjournment for the record. She does have a valid license.
Oh, she does.
I just got that from Miss Terry, because of that she doesn't have a valid license. Also.
She does.
So I'll just go ahead and dismiss this.
Another wasted sticker. Any objection?
Butter sticker.
Yeah.
Maybe you can peel it off.
Yeah, well, I tried, but it took paper with it. And that's expensive. March 19, 2025, case dismissed. I don't know why. Why did I say the name? To let you know I knew what it was. Lie down. I don't know. Court calls the case, People versus Kiana Patterson.
Patterson, you should be present via Zoom.
She is. Miss Patterson, can you state your name, please?
Kiana Patterson.
Thank you.
Thank you, Your Honor. I have discussed this matter with my client as well as Ms. Blondie, and there is a offer as well as a potential offer if Ms. Patterson were to get a valid license.
Got it.
She believes she would be able to do so, but is asking for a somewhat lengthy adjournment to see if that can happen if the court would maybe allow 4 weeks.
And my only concern, Your Honor, is she does have an active warrant, case 232-006, which is another driving suspended.
Yes,
And our,
232, so 14-2.
okay, so she's gonna need to take care of that.
She will, and actually, Your Honor, she wasn't arraigned in front of the magistrate for custody on that active warrant when she was arraigned on this one. It was given a PR bond. And looking at JIS, it looks like the warrant cancellation was not accepted by legal for whatever reason. I did contact that attorney, but I didn't so we don't know what on that, but yes, it does show as an active warrant in the system. Thanks, sir.
We'll adjourn this one to May 7th, 2025, 9 a.m.
Thank you, Your Honor.
Thank you.
Thank you.
Bond continued. Court,
Ms. Patterson, we'll be in touch.
Okay.
thank you. Court calls the case, People versus Ava Tompkins.
Assistant Public Defender Natalie Tate with on behalf of Ms. Tompkins, who should be present via Zoom.
Ms. Tompkins, you'll need to turn on your camera and unmute.
Sorry.
Okay, there she is. Your name?
Ava Tompkins.
Thank you. All right, what are we doing?
Thank you, Your Honor. Ms. Tompkins is going to be entering a guilty plea under HIDA in this matter, as charged.
Tompkins, can you raise your right hand?
Yes.
Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
All right. State your name again for the record.
Ava Tompkins.
All right. Ma'am, it is this court's understanding that you are going to be pleading guilty to the charge of retail fraud in the 3rd degree. That's a misdemeanor, punishable by up to 93 days in jail, $500 fine plus court costs. The fine could be increased to 3 times the value of the property taken. If that's greater than $500, that would become the maximum fine. You understand that?
Yes, Your Honor.
All right. Still wish to plead guilty?
Yes.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes, Your Honor.
Because of that, you're giving up certain rights. You're giving up your right to call witnesses to speak to you at trial or to have this court compel their attendance. You're giving up your right to see, hear, and question all witnesses against you at trial. You're also giving up your right to be a witness for yourself or to remain silent, not have that silence used against you. And you're giving up your right to be presumed innocent until proven guilty beyond a reasonable doubt. You understand that?
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes.
All right. Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No.
Anybody threaten you or coerce you?
No, Your Honor.
You're doing this voluntarily and of your own free will?
Yes.
and because you believe that you are indeed guilty of this offense?
Yes.
July 9th, 2024, at the location of 2000 Waters Road, Pittsfield Township, Washington County, State of Michigan, what'd you do at the Target store that makes you think that you're guilty?
I attempted to leave with products that I didn't buy. But was no.
Okay, so you went into Target. Was Target open to the public at the time?
Yes, Your Honor.
All right. Did you have anybody's permission to take those items and to try to leave without paying for them?
No.
And these items that you took, these were items that Target had offered for sale?
Yes.
Counsel, have I complied with the court rule? Would it be proper to accept this defendant's plea?
I'm satisfied. Yes, Your Honor.
Court will accept the defendant's plea of guilty to this charge. Defendant is referred to probation for a pre-sentence investigation and report. Sentencing in this matter will be April 30th, 2025, 12 p.m. noon, apparently. All right. Ms. Tompkins, thank you very much. Hold on the line. We're going to put you into a breakout room with probation intake so we can start the probation process, okay?
Okay, thank you.
Thank you.
Thank you, Your Honor.
Court calls case of the people versus Jason Williams.
Echelon for the people. Good morning, this is the public defender of our hearing on behalf of Mr. Williams. Mr. Williams, please state your name for the record.
Jason Williams.
You got it. All right. What are we doing?
We are asking for a relatively longer adjournment. Mr. Williams is engaged in treatment. And Ms. Levy would like to see him continue that treatment before we resolve the case. So that's fine.
And that's right. The concern I expressed to Ms. Kearney was that we had a lot of missed samples.
Yes.
For community corrections, and that she let me know that he's been testing with a different facility. But I suppose there's been some challenge getting those results to community corrections. So right now, it looks like there's no testing happening, which is very concerning given the charge. But I'm hoping that we're going to see it. So I actually was wondering if we feel like a slightly shorter adjournment would be the April 2nd, so we can see the testing figured out, and then maybe like give them a chance to do better on bond to see if we can earn.
I'm glad you guys talked this thing through. I already wrote April 23rd.
Oh, okay,
What,
that's
the
great.
2nd?
23rd sounds great.
I'm just
All my concerns.
and I understand Ms. Lottie's concern. I have been speaking with Mr. Williams about this like virtually almost every day. I do know that he's gone to test and Novi multiple times, and he has spoken with Ms. Kerr about getting the results released. I know they spoke yesterday. I don't know if you have an additional update, Mr. Williams, but he is testing there.
April 23rd,
Thank you, Your Honor.
2025. Thank you. Court calls the cases of the people versus Robin Nobles.
Conrad Solar on behalf of Pittsfield Township.
And actually, a lot of the people.
All 4 cases.
3, correct, Your Honor?
3.
Oh.
Last one's a 1.
This is a public defender that would pay with on behalf of the Nobles in all 3 cases. Ma'am, can you please state your name for the record?
Robin Nobles.
Thank you.
In the Pittsfield Township case, it says 1200-1201. I'm moving to dismiss both of those cases.
Well, that makes that easy. Any objection to that?
No objection.
Okay, those cases are dismissed.
And there is an offer available for the state case.
Can I, just before you do that, I just so that you understand she has a felony.
Felony? No, Your Honor. Yes.
You said felony, refused the word. I didn't know if I said it in French this time. Yes. That I want, I'm going to arraign her on now if you, unless maybe you want to speak to her before I do. Just get the charge. It's for possession of cocaine.
May I ask what the offense date is, Your Honor?
Offense date of September 3rd, 2024.
I would be comfortable moving forward with the arraignment and addressing that. I've spoken with Ms. Noble several times. I did not know about this new case warrant, but I do understand.
All right. Does that, in terms of any resolution on the other matter, does that change the people's perspective?
No, Your Honor.
Okay. So we're going to do this one.
You arraignment, Your Honor?
Well, no, you had a resolution
Yes,
of
we did,
this
yeah.
case. So let's do that and then I'll arraign her.
And the resolution on the other case, Your Honor, is to plead to the count of retail fraud, third degree, and any creating misdemeanor, $500 fine or treble amount, bond rate 750-3564.
That is
She's pleading no contest.
correct, Your Honor. I did discuss that offer with my client and she would like to accept that offer today, pleading no contest as the basis being.
All right. Ms. Nobles, can you raise your right hand? Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Your Honor.
State your name for the record.
Robin Nobles.
All right, you can put your hand down. It says court's understanding that you're going to plead no contest to the charge of retail fraud in the second degree. That's a misdemeanor punishable by up to 1 year incarceration, a $2,000 fine plus court costs. The fine could be increased to 3 times the value of the property taken. If that's greater than $2,000, that would become the maximum fine. You understand that?
Yes, Your Honor.
Still wish, do you understand also what a no contest plea is? I guess I should ask you that.
No, I don't.
You don't. Okay, a no contest plea means that you're no longer contesting this charge of retail fraud in the second degree.
Okay. Yes, Your
What-
Honor.
What? So is it a count 2?
And attempt to retail fraud, third degree misdemeanor.
All right.
$500 fine. 750-3560.
So she's pleading to an added count 2.
Yes, Your Honor, that's correct. Follow the training.
We're dismissing count 1.
That's exactly right.
All right. And it's a no contest plea. All right. So let me start again. Since court's understanding you're going to plead no contest to the charge of retail fraud in the third degree. That's a misdemeanor punishable by up to 93 days in jail, $500 fine plus court cost. The fine could be increased to 3 times the value of the property taken is greater than $500. That would become the maximum fine. You understand that?
Yes, Your Honor.
All right. With reference to a no contest plea, it, like I said, first of all, means that you're not further desirous or wanting to contest this charge. You understand that?
Yes, Your Honor.
You understand that the court that I would be and have reviewed the police report in the case, and I would accept the facts in that police report as true. You
Yes, Your
understand that?
Yes, Your Honor.
Okay. The other thing you need to understand about a no contest plea is that for purposes of sentencing, the court will treat you the same as though you had pled guilty. You understand that?
Yes, Your Honor.
All right. Any other questions you have about a no contest plea?
No, sir. No, Your Honor.
All right. Basis for the no contest plea?
Such a civil liability, Your Honor.
All right. So Ms. Nobles, to that charge of retail fraud third degree, how do you plead?
Guilty.
Or Ms. Nobles, do you plead guilty, not guilty, or no contest?
No contest, Your Honor.
All right. Thank you. Now you understand that by pleading no contest, you will not have a trial of any kind.
Yes, Your Honor.
All right. Because of that, you're giving up certain rights. You're giving up your right to call witnesses to speak for you at trial or to have this court compel their attendance. You're giving up your right to see, hear, and question all witnesses against you at trial. You're also giving up your right to be a witness for yourself or to remain silent, not have that silence used against you. And you're giving up your right to be presumed innocent until proven guilty beyond a reasonable doubt. You understand that?
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes, Your Honor.
Are you on probation or parole?
I am not, Your Honor.
Has anybody promised you anything other than what's been stated here today on the record to get you to plea?
No, Your Honor.
Anybody threaten you or coerce you?
No, Your Honor.
You're doing this voluntarily?
Yes, Your Honor.
and of your own free will.
Yes, Your Honor.
All right. Court has been provided and has reviewed Pittsfield Township Department of Public Safety report for their case number 245209. Any objection to the court having reviewed that report?
No, Your Honor. No, Your Honor.
Based upon a review of that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of this offense. Counsel, have I complied with the court?
Was satisfied? Yes, Your Honor.
Court will accept the defendant's plea to count 2. Count 1 is dismissed. Defendant in this matter is referred to probation for a pre-sentence investigation and report. Sentencing in this matter will be April 30th, 2025, 12 p.m. noon. Right? Ms. Nobles, I'm going to arraign you on your felony charge, but I'm going to ask you even after that to hold on the line so that we can put you into a breakout room with probation.
Yes, Your Honor.
All right. So,
Thank you.
yep, hold on one moment. Let's see what we have here. All right, court does call the case of the People versus Robin Nobles, the felony matter, and 125F 0284.
Public defender Natalie Page anticipating appointment on behalf of Ms. Nobles.
All right, Ms. Nobles, you are before the court on a felony complaint that alleges that on or about September 30th, 2024, location of Washtenaw near Hawks in Pittsfield Township, Washtenaw County, state of Michigan, that you did possess a controlled substance, that being cocaine. Do you understand the nature of that charge, ma'am?
Yes, Your Honor.
All right. That's a felony punishable by up to 4 years incarceration, a $25,000 fine plus court costs. Do you understand that?
Yes, Your Honor.
All right. First question I have for you is, do you wish to be represented by an attorney?
Yes, Your Honor.
This is a public defender case.
Thank you, Your Honor. We would waive any further reading, standing date, and also ask to briefly address bond if appropriate.
All right. Defendant having waived formal reading, standing mute. Court will enter a not guilty plea. I'll set a probable cause conference date of
April
3rd. What's today? The 19th. It actually, I'm going to put it on the 27th. March 27th, 2025, 9 a.m. Yes, that's the bond.
Your Honor. So Ms. Nobles has recently successfully completed inpatient treatment at Bear River and has been in that program. And she's expecting, as of Monday, I believe she will be moving to Grand Rapids for a sober living facility. That being said, she does live on the other side of the state. So I'm asking that any testing requirements, that she not have to come to community corrections here for intake, that any requirements they have of testing at sober living, that be allowed to count as her testing.
So her sober living is going to be in Grand Rapids.
Yes. Is that correct, Ms. Nobles, right?
Yes.
I have no objection to that, Your Honor. We're not requesting any monetary component for bond.
Consider bond at $5,000 personal recognizance bond, although the standard conditions, including no assaultive behavior or possession of any weapons. You understand that, ma'am?
Yes, Your Honor.
There's also to be no possession or consumption of any alcohol, recreational marijuana, or any illegal drug. You understand that?
Yes, Your Honor.
So here's how I'm going to do it. I'm going to indicate that the defendant is to test at community corrections. I do it, and I'll adjust it, counsel, depending on how often she's testing, but given the nature of the drug, I'd make that 2 times per week. But I will also indicate that the defendant may test in Grand Rapids, Michigan.
So, Your Honor, does she have to report to community corrections for intake?
She's going to have to call or somehow or another contact community corrections. Yes. All right. So I'll order testing 2 times per week. I will indicate on the order that defendant may test in Grand Rapids. And then I'll sign off on that order. Okay? Very good.
Thank you so much, Your
Okay.
Honor.
Thank you. Thank you, Ms. Nobles. Hang on the line and
Okay.
let's get her into probation intake. Take care.
Thank you so much. You too.
Court calls the cases of the people versus Heather Booth. 3 cases.
Conrad Silva,
Four.
yeah.
Two are shell codes, the other two are.
1. Heather Booth. No response. These are set for show causes. Here, so bench warrants will issue for the defendant's failure to appear in the 2 matters. Bond 5,000, 10% privilege. Those warrants will issue immediately in those matters. Court does call the cases of people versus Tammy Callis. 3 cases.
Conrad Silva, on behalf of Israel.
Okay. There's only 1 case on.
Yes.
Callis. No response. Bench warrant will issue for defendant's failure to appear. Bond is set in the amount of $5,000. I'll give a 10% privilege. Those warrants are to issue immediately.
Was the warrant issued in 0023?
Yes.
Thank you.
Court does call the case of the people versus Al-Haji Faye. Al-Haji Faye. No response. Bench warrant will issue for defendant's failure to appear. Bond is set in the amount of $5,000. Give a 10% privilege. That warrant will issue immediately. Court does call the case of the people versus Jason Pope. Jason Pope. Just another check. No response. Bench warrant will issue for defendant's failure to appear. Bond 5,000, 10%. That warrant will issue immediately.
Your Honor, the last case requires stage interpreter may swear influence.
Yes, you may.
Good afternoon, Roy. You're in front of the Honorable J. Cedric Simpson of the 14th District Court, Washington County, State of Michigan. We need your assistance with 2 matters this morning. Our number is 1423.
Thank you.
Thank you, sir. Do you solemnly swear to affirm that you'll interpret accurately, completely, and impartially, using your best skill and judgment, and to translate the people into Spanish and from Spanish into English in the manner now before the court, so help you God? You're muted.
I apologize. I do swear. Thank you.
All right. And hello, Roy. Good seeing you, sir.
I was saying good morning.
Yes. Court does call the case of the people of the state of Michigan versus Jose Hernandez Aviles.
Hernández Aguirres. Thank you. Muy bien, entonces abre el caso. El juzgado llama al caso de la gente del estado de Michigan versus José Hernández Aguirres.
Sí.
Aviles, perdón. ¿Está presente el señor José Hernández Aviles?
Sí, aquí estoy.
Yes, he's there, Your Honor.
Ashley Longy for the people.
And
That was
I missed
Ashley Landy for the people.
Thank you. Y se encuentra la fiscal Ashley Landy representando a la gente.
Assistant Public Defender Natalie Tate with and on behalf of Mr. Hernandez Aviles, who appears via Zoom. Sir, please state your name.
And so, Your Honor, I missed her name.
Natalie Tate.
Okay. Y tenemos a la defensora pública Natalie Pay, representando al señor Hernández Áviles. Señor Hernández Áviles, ¿me puede dar su nombre para el récord?
José Luis Hernández Avilés.
José Luis Hernández Áviles.
Your Honor, there was an offer extended in this matter, for my client to plead to operating while intoxicated, the reduced charge. I am ultimately respectfully requesting a very brief adjournment. I need to have a follow-up conversation.
Understood. I'll adjourn the matter to April 2nd, 2025, 9 a.m. Bond will continue.
And that was April 22nd.
Or April 2nd.
Second, thank you, Honor. Muy bien, entonces la defensora está pidiendo un aplazo en este caso, debido a situaciones sobre